Welcome to John Redmann, Power of Attorney, the show that aims to empower you through knowledge of the law. I'm Attorney John Redmann.
And hello, everyone. I'm Shauna Sanford. Thanks so much for joining the show. Now, whether you or someone you know has been injured on the job, workers' compensation benefits are available to help with the loss of wages and medical bills. And while all employers are required to carry workers' comp insurance, there's no guarantee that you will automatically receive those benefits if you are hurt at work.
That's right, Sean. In fact, legislation recently approved by the state lawmakers could make it even more difficult for an employee to collect workers' comp benefits.
Well, that certainly is not something that we want to hear. And John, I know that you deal with personal injury. That's your area of specialty there. But workers' comp, is that kind of like personal injury a little bit?
Well, it is very much like personal injury law. In other words, it involves injury to your body, typically, which indicates or causes you to not be able to work, or at least involves injury that requires medical care. Sometimes you can have a workers' comp injury that also involves a personal injury lawsuit against somebody, not your boss. But workers' comp injury is a very special area of the law that has its own set of laws that apply, and it requires the employer to pay for your medical bills, and while you're unable to work, it requires the employer to pay a certain percentage of your wages, 2/3 of your wages. It's a very specialized area of the law. Generally, you're entitled to those benefits almost without question, but that's changing, and we have a very important discussion about that coming up.
You're absolutely right. In fact, Attorney Ray Murry will join Power of Attorney in just a few moments to help us better understand what the law says and the whole world of workers' comp. So stay tuned. We'll be right back.
That one-on-one relationship with an adult is so important. If every day somebody is touching base with somebody and then they get to spend some time each week with that person, there's a relationship that develops. And all the communities and school services are really designed to create that one-on-one relationship.
This school has taught me so much to be the best that I can be. They never give up on me. They never give up on anyone here.
Well, hello, everyone. Welcome back to the show. No matter what sort of work you do for a living, anything can happen at any time. Maybe you have an accident, develop a work-related illness or disability. Either one may lead you to file a claim for workers' comp. But who's entitled to receive it? What benefits are available, and how do you collect? Those are just some of the questions on the table today for our guest, Attorney Ray Murry.
It is so important to know your rights, and Attorney Murry is here to help explain a lot of the ins and outs of a workers' comp claim. Ray is a graduate of Loyola Law School. He served 20 years in the U.S. Coast Guard and has been practicing workers' compensation law for many years. Ray, if you would, why don't you start by explaining to people what is workers' compensation?
Thank you, John. First, I'd like to thank you and Shauna for having me on the show, and let's jump right into it. The workers' compensation is a legal remedy scheme for people who've been injured on the job. Originally, it has its roots back to about 1921, and the idea was that someone that gets injured on their job, even through the negligence of their employer, it was to protect the employers from negligent suits that pay full legal damages. So it's a limited remedy for the injured worker, and it protects the employer. However, the injured worker doesn't have to show that the employer was negligent. He will get his benefits even if he was the negligent party when he or she when they were injured.
So I think that's really important. It is there to protect the employers.
Right. In other words, and again, I've done a little workers' comp myself over the years. The legislative history is this was created more as an added protection for the worker. That means even if the worker himself was responsible for causing his or her own injury, it's a protection for the worker. The trade-off, and why the business industry went along with it, was it capped how much the employees could get hurt. You didn't get the same benefits or remedies you would get if it was a car accident out there in the street, like a personal injury suit might allow you, correct?
That's correct, John. What it is it's the exclusive remedy, and it's a limited recovery. Basically, personnel that are injured will receive a wage loss benefit of 66% of their wage loss experienced. However, that is capped. And they also will receive their medical treatment that's reasonable and necessary to their cure, or if cure is not possible, to maximum medical improvement.
You know, an accident is certainly not anything anybody ever expects to have on the job, but it happens quite a lot here in Louisiana, across the country. But by and large, do you find that people really just don't understand what their rights are and what benefits they're entitled to when they are injured on the job?
Yes, Shauna. Many of the clients, when they first come in and they do their initial interview with an attorney in my office, they're very shocked at the limited nature of these benefits, and some are just reluctant to accept the idea that you cannot sue your employer in a regular negligence action in a district court. It's relegated to the administrative law courts of the workers' compensation.
And let me add to that, so often, and one of the reasons why you and your practice, you're so busy, is because employers aren't doing what they're supposed to do. Employees who are hurt don't know what their rights are to demand and even ask for what they're supposed to get. Maybe you could walk us through it. What counts as an injury or an accident on the job, and what are the obligations of the employer when an employee is hurt?
Okay, an accident, actually defined by statute, I believe, is a sudden precipitous event. It's an identifiable moment in time where something happens. Now, that doesn't mean that it has to be greatly traumatic. I've had injuries where people have torn their meniscus when they were simply walking upstairs. That's still a compensable
Just
claim.
hurt their knee suddenly.
Their knee while they were on the job. So if we have an accident, we have an injury to the body, we're going to look for medical treatment immediately. The employee should report it. Employers sometimes are reluctant to report it because they have safety records and so forth, things that they're seeking. I would encourage all employers, if someone reports an accident, take the right action immediately. You should contact your workers' compensation insurer. And if you're self-insured, you probably have what's called a third-party administrator, someone that administrates your workers' comp claim, your risk management area. Make a report of that claim, send that person to the doctor. The employer has a right for them to be seen by their doctor. The employee has a right to be seen by a doctor of their choice. So there's two rights there, and the employer should go ahead and take the initial information on the accident.
So even if you have, 200 days since your last accident, and it's really nice to have a clean safety record, you can be in big trouble if you're the employer and you try and sweep under the rug that an accident with one of your employees has happened. So it's more important to report the accident than have that nice long accident-free streak, correct?
I think it is. I think responsible employers are going to take that attitude. I do have cases that come in where my client, the employee, has reported the accident, and there's such a reluctance to report the claim. Eventually, the person in management that's been reported to usually finds themselves in trouble because now you're going to delay the process. And if you delay the process of getting people medical treatment, you may expose the insurer, or if you're self-insured as an employer, you may be exposed to penalties and attorney's fees for that behavior.
Well, on the flip side of that, when it comes to the employer, do you find that employers are reluctant to go to their employees to say, look, I've been injured, and we're saying on the job, but it's a work-related injury. So whether you're actually at the physical site of your job or you're off-site, still doing your job, that could still constitute as a workman's comp claim if you're injured off-site.
Yes. Generally, the rule, Shauna, is that it's the threshold. And where someone comes to work every day in the same building, that's kind of easy to identify that you've come into the parking lot. Those are real boundaries. But as you pointed out, sometimes people may drive and leave that site. And there's some case law out there, specifically McClin, that says if you're on a special mission, you're on a mission for your employer, you can still recover in your workers' compensation benefit.
If you're doing door-to-door sales and you're in somebody's home and you trip and fall down over your own 2 feet or over a rug on the floor, as long as you're working and you get hurt, you should be covered by workers' compensation.
As described by you, John, I would tell you, that's a compensable claim.
Well, I'm in favor of the worker by trade, but on this show, I'm trying to be the moderator and cover both sides.
Right. I was going to ask, how important is timing in these cases for the employers?
Timing is important as to, are you referring to reporting?
Reporting, yes.
It's both important to the employee and the employer. I would say to employees, if you think you're hurt, you've had an accident or some type of event where you think you've caused yourself some bodily harm, you need to report it. The employer, on the other hand, in order to act prudently, needs to send you out for a medical evaluation. Usually they have an association with clinics. Most of the employers are not the workers' comp insurance, that someone can send you to a clinic for a basic evaluation of your medical. If you hesitate, it'll become harder to prove and it becomes a factual dispute in many cases.
And the reason is, suppose you get hurt on the job. Maybe you feel something pop in your back when you're lifting heavy boxes, and you think, well, maybe I can ignore it and then you don't say anything, and then the next day you're back, you can't even get out of bed, and you call your boss and say, yesterday something happened in my back. Well, there's a good chance your employer's not going to take your word for it and say, how do I know you didn't throw your back out while you were at home last night? And then you've got a real issue saying that I hurt my back at work, right?
That's correct. A general rule is as soon as you think that you may require some type of medical treatment, go ahead and make your report of it. And it's still, I mean, good workers don't want to run into their boss and say, listen, I pulled my back, it may be something in the future, because it's hypothetical. So if it happens in your hypothetical there, John, you said, you know, the next day, but sometimes back injuries take 3 or 4 days before you realize it's not just a pulled muscle and I'm not recovering. As soon as you come to that realization, you do need to make the report to your employer.
Yeah, or, you know, it may be something where you hurt your shoulder, but you can work with one arm, and so you're trying to, or maybe you work by yourself and you can't get to the foreman anytime soon. But on the side of caution, report it and say, I pulled a muscle, I did something, it feels bad, I think I'm okay, but I'm just letting you know, because that's a stitch in time that saves none. Because if it turns into something that is more serious, nobody can dispute, or it's hard to dispute whether or not that injury happened on the job or happened off the job.
That's correct. And it's also equally important as if you seek medical treatment. Sometimes my clients have been injured. Maybe over the weekend they realize the gravity of this injury. They go to the emergency room. Make sure you report it as to what happened. Be factually correct and accurate. Tell that
and don't lie to anybody when you're in the emergency room. Don't try and do your boss a big favor and say this happened at home. Sometimes some bosses out there, and if you're a boss, don't do this. Tell the employee, tell them it happened at home. Use your health insurance. Terrible idea, right?
Absolutely, because once you start, for lack of a better word, lying, what you're actually doing is committing fraud. If you're lying to try to get workers' compensation benefits, you are committing fraud, and there's a criminal charge for that. But if you're shifting it onto your health care, or maybe your wife's health care, sometimes I encounter that because your boss told you to, well, that's health care fraud against, that's fraud against that health care carrier. They shouldn't have to pay for the injury that you sustained at work.
You get in real trouble for that,
Yeah,
too.
so let's say you are injured and you're in a quandary. You just don't know what to do. You're not really sure if it's something that is going to be a legitimate claim or if you should move forward with filing a claim. Let's say you do need medical treatment and you decide initially to go through your own health insurance. Is that going to backfire on you at some point if, in fact, it turns out that it is a workers' comp case?
Well, it'll certainly be a medical record out there. If you're using your own health your own health care insurance, but you report it accurately. You say, listen, I hurt myself. I don't think so. Because then that health care provider, that insurance company for health care, can seek reimbursement from the workers' compensation company.
Okay.
Or insurer or employer.
So at what point do you get involved? At what point do I turn to a lawyer like yourself and say, look, this has just gotten more and more complicated? At what point does that usually happen? Well,
it's important that the public know you actually don't need a lawyer. You can handle your claim pro se in the Louisiana Workers' Compensation, under Louisiana Workers' Compensation Commission, even through trial before the administrative hearing officers, our workers' comp judges. However, you should give that a lot of consideration because there's going to be a lot of process and legal process that you can make errors in.
Just to add, pro se means without a lawyer representing yourself.
That's correct. You may represent yourself without a lawyer. When do they usually come to me is when they're not receiving their medical treatment, they're not receiving their indemnity payments, they've followed the proper procedure, they've reported the claim, and for whatever reason, their frustration level has risen to a point where they decide to seek legal assistance. I would tell you that if you're going to make a claim, it's probably better early on, before you give any recorded statement or take other action interacting with a workers' compensation adjuster, to go ahead and retain a lawyer. Lawyers that represented your
Better
workers.
safe than sorry, just to make sure you don't accidentally screw up your rights.
And a lawyer in workers' compensation has a limited recovery. A fee cannot go over 20%. That's under the law, 23-1141. Any attorney that's charging, if you have a workers' comp claim and they're charging you more than 20%,
they're violating the law.
They're violating the law.
Very important information. As a matter of fact, we have some questions from our viewers. And when we come back, we are going to take your questions for our guest, attorney Ray Murry. We're talking about workers' compensation. Stay tuned. We'll be right back.
never forget our best teachers, the ones who do so much more than teach. They inspire and insist we bring our best in everything we do. We find those mentors in our Catholic schools. It's why Catholic school graduates consistently go on to college, land better jobs, embrace faith, and lead. Louisiana Catholic Schools, in a class of their own.
Hello, everyone, and welcome back to the show. We are talking about workers' compensation, and it is time to get you in on the conversation. So let's go ahead and get your questions for our guest today, Attorney Ray Murry. And the first question that we have is, how long do you have to file a claim? Getting back to that timing issue.
Yes, Shauna. Workers' compensation is a bit complicated in this area. There's actually, from the time of your injury, if you're never paid any workers' compensation benefits and you're never paid any medical benefits, you have 1 year. And we're using a word here, file a claim. I'd like to point out that when I talk about filing a suit in workers' comp, you'll hear me use the term disputed claim. Okay. And that's where you actually file the form before the administrative law judges to have your case heard. The prescriptive period, or the time, runs out a year, like it does in other personal injury in the state of Louisiana, if they've never paid anything. However, if they are paying you workers' compensation benefits, indemnity benefits, it's 1 year from the last date you received the benefit. Or it can be extended out to 2 years or 3 years if they're paying you a partial wage loss. Medical treatment is generally 3 years after your last treatment.
Okay, so how does this process actually work? I'm sorry, when you file a claim, how soon should I start receiving my benefits?
Well, you should receive your benefits within 14 days.
Oh, okay.
And when we say benefits, let's clarify, there's two different benefits out there. There's the wage loss benefit, what we're going to call indemnity, and then there's the medical benefits. Medical, you should not receive any bills on. Those should all be covered by the workers' compensation adjuster. But after 2 weeks, they should be paying you your benefits. Recent legal changes, they don't have to pay you for the first week, but then when they do commence them at the end of the second week of disability, they're supposed to reimburse you for the first week.
Yeah, and should is the big operative word here, because if the employer, rightly or wrongly, disagrees that you are disabled, if the employer disagrees that this injury is one that is covered or should be paid, they might not pay you anything. In other words, just because you file a claim, a disputed claim, does not mean that the employer suddenly, all right, we got to get out the checkbook or the insurance for the employer, the workers' comp insurer. They don't have to suddenly start paying. They could, rightly or wrongly, refuse to pay, correct?
And that's a problem because late payment can subject an employer and or their insurance company to penalties and attorney's fees.
So there's a risk if they don't pay.
That's correct. And that's why I would go back and say that's why I would encourage all employers, report the claim and report it to the appropriate authorities, whether that be your third-party administrator or your insurance, and let them get active in that claim.
Yeah, and that's good advice for employers, because if you don't report the claim, a lot of these insurance policies, well, two things. One, they require the employers to report when you think you may have a work comp claim situation. And another thing, and I've seen it many times, where the employer is supposed to say how many employees you have working for you and pay your premiums to cover all those employees. Because if you're trying to be a little clever with your bottom line and you're not paying everything you're supposed to pay, you might find yourself without workers' comp insurance on your employees, and that's a whole other world of trouble for the employer, right?
Yes, John, and one of the biggest misconnects or disconnects, if we would, is that employers believe that the person that is injured on that job doesn't work for them. And many, many times that I will encounter where employers are saying, he's not my employee, I give him a 1099. And you have to... A 1099
is what? An independent contractor, right?
That's how you would give the taxes for them. But that alone doesn't mean that someone's not your employee.
But I think that's great. Could you define, who was considered an employee?
And versus a non-employer, an independent contractor.
Actually, there's a lot of jurisprudence on this. There's about 9 elements that are considered under workers' compensation as to define whether someone's an employee or not. Just because they don't work directly for your company or just because you don't have them on your workers' compensation insurance coverage does not mean they're not an employee. It is defined, the big things you want to look for is how much control do you have over the person that's performing on this job. If you're telling them when they come to work, if you're paying them an hourly wage, if you're, who owns the tools, who says how the job will be done, who do they report to, all those elements. In fact, there's been up to 9 elements I'm aware of jurisprudentially that have been considered. And then, even if you feel comfortable there, you must understand that there's a thing called the manual labor exception. If you're hiring someone to do manual labor, there is a presumption that he will be categorized as an employee for workers' comp. The idea of categorizing someone as an employee in workers' compensation and employment law may be very different.
So you could be a part-time employee, you could be a contract employee, and still, if you're injured in any way that's connected to that job, you could be considered an employee and could file a workman's comp claim.
For workers' compensation purposes, you may still be considered an employee. And the law tends to look broad in this area because, remember, this person doesn't have a remedy. He can't go get a lawyer and bring a negligence action against the employee. And we don't want the public to have to pay for his medical treatment, the fact that he can't work. So a lot of times the law sweeps rather broad on this issue as to whether you're an employee or not. Another thing that employers should really pay attention to is subcontractors. Even when you have legitimate subcontractors and they have their own companies, make sure you get that certificate of insurance on workers' compensation, because under our scheme of law, we have what's called the statutory employer, and many times I run into this, where the initial or direct employer does not have workers' comp insurance. I can then name the contractor above and go against their workers' compensation insurance for the benefits of my client, because they're a statutory employer.
An example is you got a general contractor building a building. He's got a subcontractor, maybe it's a sheetrocking company or a plumber. The plumber's got employees. The employee of the subcontractor, the plumber's employee, gets badly injured. The injured employee comes to see you. You've got a claim that's worth a lot of money because the guy's badly injured. The plumber says, "Oh man, I don't have no insurance." The general contractor, his insurance is on his workers' comp insurance is on the hook, correct?
That's correct, and that's called the statutory employer.
So the moral of the story, if you're the general contractor, you insist that your subcontractors show you their proof of insurance.
And again, a point you lightly touched on before is because at that point, many times, the general contractor's insurer will come back and audit all the subcontractors, and if those subcontractors do not have workers' compensation insurance, they'll figure out how many employees those subcontractors have, and they will alter your premiums and charge you back premiums for it.
That's a lot of money.
Sure, and most employers out there, I'm an employer myself, and these guys are trying to make a living, and they're trying to do the right thing. I think I'll say the majority of employers in Louisiana.
I agree.
And it's just a question of knowing what details to look for to keep your business solvent.
Right. Okay, so here's another question for you. A viewer wants to know, do I have to file a claim? So is it something that I have to take advantage of if, in fact, I am injured on the job?
The answer, I think, would be no. If you don't want your workers' compensation benefits, you don't have to make a claim for workers' compensation benefits.
You don't have to do that.
I don't think it's mandatory in any way. It's up to that person.
I mean, if you're not seriously injured, no. But if you're seriously injured, just somebody's going to have to pay those medical bills.
Someone is going to have to pay.
If it's going to be you, well then, that's your decision.
Now, if I do decide to go and file that claim, am I giving up my privacy rights in any way, shape, form, or fashion? We have a viewer here who says, do I have to take a drug test if I'm injured on the job? And what about my medical records? Do I give up privacy when it comes to my medical records?
The answer, the drug test, is not a simple answer. The law in workers' compensation, generally speaking, your negligence doesn't apply, but there are 4 defenses to a workers' compensation claim that employers have a right to assert. And those are, the number one is fraud, people making false claims. That's an absolute defense. And failure to use a safeguard, which is not used a lot, horseplay, and intoxication. I'll address intoxication last. Intoxication there is a presumption that if you fail a drug test, that your intoxicated state contributed to the cause of the accident, then you're not going to get your workers' compensation benefits. Do you have to submit to a urinalysis? The answer is probably so. If you have signed a promulgated drug policy with that employer and you refuse, then you're probably going to put your benefits in jeopardy.
In other words, if the employer, when you take the job, says, here's our policy on drug testing if you're hurt, read it and sign it. If you've done that, then the employer definitely has a right to require you to do a drug test if you're in an accident or injured, correct?
Yes, I would agree with that.
Okay.
However, many times there's not a promulgated drug policy, and we have our jurisprudence has came back different ways. Different circuits, our appellate circuits have held it different ways. They have allowed drug tests that come in that arose from an emergency room where there wasn't a promulgated drug policy, and I've actually tried cases where it was held out.
So they'll throw out the drug test. And what happens if the drug test comes in? There's a presumption, but what does that mean?
Well, that means that the judge is going to give strong consideration to the fact that that accident may have occurred based on the fact that the injured worker was intoxicated. However, I think that you and I actually worked on a file together once, John, where a roof collapsed, and one of the gentlemen that fell did not pass the drug test, and the other gentleman did. So there were, in that case, the judge held that it had nothing to do with
the injury.
And in those cases, he or she would still get her workers' compensation benefits.
Believe it or not, we are out of time for this show, but I'm so glad that you're going to stick around for another show because we have so many more questions. This is such an involved topic, and we've had such a great conversation. So thank you so much for being here for part one. We've had such a great time today, and we appreciate all of you out there for being part of the show, for joining us today. Now, we've only scratched the surface here. There is so much more to learn. So we're going to pick this topic up again next week for part 2 on workers' compensation. Be sure to join us then.
Many thanks again to our great guest, Attorney Ray Murry, and thanks to all of you. We look forward to having you back next week. But before then, be sure to send us your questions and feedback, and get more information about this show by visiting johnredmannpoa.com. And don't forget to follow us on Twitter and Facebook. We'll see you next time.